আদার সাইড নিয়ে স্টেটের এখন আসেনি, স্টেটারে আসুক আসুক এলে তাও ডাক। Yes.
Item number 32, I am mentioning for item number 32, as per instruction of the petitioner.
Need not mention. When the matter will be called, you submit.
Grateful, Lordship.
ডাকুন।
Item number 1.
Nobody for the state?
Lordship, CD has not been allotted till. Brief also, Lordship. Short accommodation is required. Brief also not allotted, Lordship.
The learned.
Item number 2.
Symbol. The learned
Item number 3.
My lord, I appear on behalf of the state.
They taken 22 packets. And each packet has got inventory by planted magistrate. Packets have got containing of 20 grams. And 20 chemicals. Limited packet. So each sample containing 46-45 grams. My specific consumption that after substance magistrate conducted inventory and inventory material magistrate Jalpaiguri for report.
The entire.
Packet packet of 22 samples. Each packet is sample containing of 50 grams. But the chemical report those are different. All are different. Kinesis is inventory report and the chemical report from the chemical.
Complete.
All started by the landed manufacturing process certification. Thereafter, since certified material secondary for chemical. This is the law. If something certified by the magistrate and saying another thing for why it is different, another material saying we could be magistrate.
My lord,
Complete.
No fun.
Complete.
250, page number 250, my lord, CFSL report. My lord, main report is in the lower court case record, my lord, and in the CD it is reflecting, my lord, 158.61 kg has been contravened from the exclusive possession of this present petitioner, my lord.
Page.
250.
Yes.
My lord, he is the owner and the driver of the vehicle, my lord. $110, my lord, is the registrational certificate of the vehicle. He is the owner of the vehicle.
Learned counsel, will both of you carry on? Yes.
My lord, registrational certificate of the vehicle from where the gaja has been recovered, my lord.
Hmm.
110.
Yes. What do you intend to submit?
My lord, he is from his exclusive possession 158.61 kg of gaja was recovered, my lord. From his possession, my lord. My lord, Caesar list page number 14, 15, 16, 17, my lord. He is very much involved in this case.
Nil. Nil. Yes. Hmm? Yes.
Kindly call me. Copy, madam. Copy. 50 gram of it. They are saying 158 kg. What is recovered decided by the chemical examiner. He is saying the learned magistrate say 50 gram packet sample sent to individual packet. And chemical report showing that 46-45 gram sample packet is which to madam. What contravention saying? What is something? Magistrate will send the 50 gram of sample for each packet, my lord.
Which page you have annexed?
Not Alex, my lord.
Then?
207 copy, my lord. Kindly gone to the case diary, my lord. Case diary. Inventory, my lord.
Sure.
Kindly gone to section.
Clarify the-
2, my lord.
Clarify the discrepancy being raised by the petitioner, counsel.
ইনভেন্টরিটা দেখান। উনি বলছেন তো 50 গ্রাম লেখা আছে।
When you were asked for, you did not provide. Then you.
এখানে যখন ইনভেন্টরিতে আপনারা কেন 48 গ্রাম
না আমরা 50 গ্রাম করে নিয়েছি ম্যাজিস্ট্রেটের সামনে নিয়েছি আমরা
My lord, before the magistrate, my lord, 50 gram.
Weight of sample drawn.
Sample down is 50 gram. This sample seen and then malab so sent to the kindly see the malab report malab once malab. Kindly
Which report?
malab.
Which page?
My lord, CFSL report 250, page number. আপনি তো অর্ডিনাল পাচ্ছেন? হ্যাঁ। My lord, all these things are matter of trial, my lord. Huge quantity, my lord, recovered from the present petition. 20 kg is the commercial, my lord. 158.61 kg, my lord.
Which portion you are relying upon?
Chemical examination malab made weight of exhibit argument malab weight they received 46, 45, 46. All are well not
My lord, these
Nil. The learned counsel representing the petition.
Item number 4.
My lord, no CD also, my lord.
Voting, the Lord Council.
Monday
represent-
Read down.
Item number 5. Regarding the arrest of a woman after sunset. My friend was instruction regarding. I relied upon the memo for arrest. This is annexed to my.
Anything more?
One thing about the source information, right? But I just reacted, but it was received at 4:15 PM. But that is reflected page 9 of that. But thereafter, the time of arrest, but as per the memo of arrest, is 6:20 PM. But the arresting officer, is PSI Shurodi / male officer, at the right upon 45, where it is stated that after sunset, my lord is well aware of it. That after sunset,
No, you place.
43 minutes.
And 43-1?
And 43(5) is with respect to the arrest of a woman.
And 43-1?
43(1) is salary for it. Someone says that in making an arrest, the officer or the other person making the same shall actually touch or confine the body of the person to be arrested unless there be a submission to the custody by word or action.
Provided?
Provided that where a woman is to be arrested, unless the circumstances indicate to the contrary, a submission to custody and oral intimation of arrest shall be presumed, and unless the circumstances otherwise require, unless the police officer is female, this one, unless the police officer is female, the police officer shall not touch the person or the woman for making arrest. But I am harping upon 45. But save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain prior permission of the magistrate of the first class within whose local jurisdiction the offence is committed or the arrest is to be made.
Hello.
That's okay.
Page 10 of the application, the FIR. Page 10,
Yes.
second paragraph. At about 5:10 hours, my source identified the suspected lady who is standing near the Chota Hanuman Mandir at Matigara Bazaar After a hot chase, we managed to apprehend the suspected lady. I introduced myself and the raiding team as a police officers. I apprised her about the information and started to examine her. On interrogation, she disclosed her address and I mentioned above. On interrogation, the detained lady, so the detention was made around 5:10, confessed that she is possessing and carrying a huge quantity suspected to be a brown sugar with her. As per the provisions of section 50, now on the next paragraph, last 3 lines, at about 5:30 hours, Sri Orindam Bhattacharya IC Matigara PS arrived at the spot as gazetted officer, where I briefed him the information in a nutshell and also introduced the witness as noted above. Here, I will pause for a moment. Notice was given to her, and after that, labeling was done in front of her. At 7, it started from 5:40 hours to 6:15 hours. 5:40 hours. Labeling was done. Her signature is there. তুমি বলেনি একটু বাবু? Her signature is there, Lordship. So she was detained before 6 p.m. Now, the order passed by the coordinate bench, same situation. Detention was made around 4:50 before 6. So they also took the same plea before the coordinate bench, rejected.
Justice Ajay Mukherjee?
Yes, Lordship. Rejected.
Nothing precluded the investigating agency from getting hold of a lady officer. I'm not even on very well, my lord. Magistrate's permission, prior permission would not be obtained. What precluded them from having an inquiry source information was still received by both. And they were aware of the fact that it was a lady. But what precluded the investigating agency? But at 6:20 p.m. a lady cannot be arrested, my lord, by a male officer. My lord, I'm not aware of that judgment, my lord. I have not been handed over the copy. I'm not harping on that as well. But my lord, this is a gross violation of 43. My lord, if she was arrested by lady officer, I have no case. I am not even on the point of magistrate's permission. Although that ought to have been followed. They had ample time, my lord. They had the time to inform the magistrate, the executive magistrate to come for seizure. They carried out all formalities. My lord, one more formality they could have carried it out.
Moreover, Lordship, in this kind of cases, they are not raising this point before the special court at that relevant point of time. After that, what happens? Once they are produced, they are taken it for remand. Once remand order is passed by the learned trial court, before whom he or she is produced, this question of illegal arrest goes at that point.
My lord, it is the duty of the magistrate to ascertain whether she was communicated on the ground of arrest and whether she was arrested by the appropriate authority. But in this case, a lady officer.
Exactly, I'm on that point, Lordship.
That was not
Once an order is passed for remand, the question goes.
So my constitutional right goes, my lord. According to my learned friend, if on remand, my constitutional right goes. But it is a gross violation. Kindly, my lord. My lord, a lady-
Same as this one.
My lord, I am not aware of the facts of that particular.
It is
It could be different, my lord. I am not aware of it, my lord. But as far as 43(5) goes, my lord, this is pattern the point.
Herein, I think in the open she was searched,
Yes.
but in this case, which learned APP is citing, herein she had entered a room, entered a house,
Yes.
wherein she was searched and
Right.
later on
My lord, I'm not-
at about I think 8 or something.
8 something, yes.
My lord,
Or beyond
search,
that.
my lord, search, my lord, the constable will take her to a secured place and search. My lord, I'm not on that, but I'm only on, my lord, 6:20 p.m. on it is after sunset, my lord. My lord, 43(5) I'm completely covered by, my lord. My lord, only on that, my lord. My lord, any stringent condition, my lord, because it's a violation of her rights, my lord.
Moreover, from the arrest memo, you will find, Lordship, that there was a lady constable present out there.
That doesn't matter. The arresting officer has to be a lady.
Which page?
Page number 12 of their application.
Page number 12 of the application.
My lord, she is signing in column 11. Kindly see, my lord.
So we do not even know whether she was party during the search of the lady. I am not on that, my lord. I will not ask of that. But my lord, I am only on one thing. Only one.
The thing which you are submitting should be digestible.
I am not asking that. My lord, I am only on this issue, my lord, that male officer arresting at 6:20 p.m. my lord, absolutely impermissible. My lord, any condition, my lord, stringent condition, my lord, she is a lady, my lord. Kindly, my lord, consider it. My lord, that is all.
Right.
Kindly. He gave us.
You know.
Well, I was in that.
ঠিক আছে।
Well, I had a copy, but I did not want to overburden my lordship. It's a voluminous judgment, but perhaps that point does not stand. Well, because as far as arrest and detention go, this is just for the academic purpose. Well, detention and arrest, they are totally different. Well, which has been subsequently explained in beyond demand. Well, detention, they had every actual opportunity to detain the person and keep her till the lady officer arrived. But that was also not done. Because I was on that. Totally different. Detention, arrest, and I wanted my lord to consider that issue. Wait.
কোনটা এটা? না, 6 নম্বর।
Item number 6.
My lord, I appear for the stay.
Next Tuesday. Already Monday, Tuesday, Wednesday are filled up. CD available? কি বলেন? For the Tuesday দেখুন তো Tuesday বা Wednesday.
নেক্সট সার্কিট বল না, নেক্সট সার্কিট বলতে দেব।
My lord, then place before next available circuit. Next circuit.
Next circuit. Let it come from the bar. নোটা আছে কবে? বুধবার। Wednesday?
My lord.
Mr. Das, why are you
Wednesday.
কি আছে?
আচ্ছা ওই আগেরটাতে লিখে দেবেন from the memo of arrest itself.
Your Lordship, item number 7 and 9 are both.
Item number 7.
7.
Item number 7 and 9 are from the same PS, same PS case number.
Same cause of action.
Same person, even petitioner's counsel is also same.
Acha. But both the CDs are there.
Only one CD.
One CD.
100 kg.
No. Let them submit. They have the instruction, both tangible and intangible. Let them utilize the instruction. Lord Counsel, use the microphone.
Yes.
Well, the case has been started under section 20B, Roman 2C and 29 of the NDPS Act. And the case has actually the case has been started by way of source information. The police has got the source information. They have put up a Naka.
What has been recovered from you?
100 kgs of gaja, Your Honor. I am coming to that point. Well, Naka checking has been set out, and thereupon one vehicle was apprehended, and thereupon these two accused person has been detained.
How many persons have come up?
To 2% at the point of time. At
No.
that point of time, 2% was there.
Now it is
3%.
Niranjan.
Now 3% is there. One.
The petitioner is Niranjan.
Niranjan and Roshik is there.
Item
Oh,
number
acha.
9.
এই
19.
আরেকটা দিন। Item number 9, 7 and 9. 9 টাও দিন।
উনি বলছেন যে একসাথে করতে চাইবে।
রশিক রহমান।
Roshik, yeah.
Yes.
2% has been apprehended, and then search, seizure list and memo of arrest, everything has been prepared. My lord will find
On the place of occurrence, only 2 persons have been
has been
arrested.
detained.
Thereafter, during investigation, the
One other person has come into
Other
there was absconder as per the.
he has not come up.
He has not come up. Now, my lord, if your my lord goes through all the documents which has been produced by them, my lord will find first the ground of arrest is nowhere in the record. In entire record till to date, after the filing of the charge sheet, nowhere it is there. In the form, it as mentioned in the judgment of SCR 2025, volume 2, page 424. May I provide the judges? My lord, this is paragraph 21 is very much important.
cited.
My lord,
Is it cited?
cited, man.
Give the citation.
Well, I have 2 copies. One copy I have kept.
Provide them.
21. Indian conclusion has been drawn in the judgment, Your Honor. What is to be done at that point of time?
Yes. Which portion?
My lord, the entire conclusion has been revealed that ground of arrest how to be made, or in what manner has to be made, that's
Yes.
mentioned, Your Honor. I don't have the copy, I think I have to go from a mobile if my.
Yes. Then
If from perusal of entire record, you will find that this provision has not been followed by the prosecution from the date of the seizure, arrest or whatever it is. Now, my lord will kindly come to the FIR. It is page 24.
page 22.
4. 24. Page 24. You got it?
25, yes.
25. You know, in the last. In the last third line, from the last third line, from the bottom third line, third last line. Therefore, I searched and detained as mentioned above under the videography by CB Constable Nawab Nasiruddin, the member of the police team, from the mobile phone of the Khoribari. Yeah, got it.
Yes.
Now this that has been done by the mobile phone of the Khoribari place of one Nasiruddin, that the constable. But my lord, from the entire record till now, I have not got the seizure list of this mobile phone. which has been used for videography of the search seizure and entire operation. I have applied for the search seizure list, but I have not got it entirely. So this also creates a doubt in the prosecution story here. My lord. And my lord, moreover, from the vehicle or from the person, neither the driving license nor the authorization has ever been seized in their name. And who was the driver and who was the actually authorized person has not been come up in the investigation. It creates a complete doubt, Your Honor. This 2% has been just been apprehended and has been languishing in the jail custody for 9 months, Your Honor. I'm claiming for bail in that respect of non-compliance. And this series seizure, that is non-seizure of the mobile phone and the custody, Your Honor. So after considering all the materials, my lord may pass the necessary order as well.
Altogether, how much quantity of gaja has been recovered?
That was, as per their allegation, is 99.95 kg. Almost 100 kg.
Yes.
My lord,
One for one minute. The Rashid Rahman, once has filed his application before this court and none moved at that point of time, and that was rejected. None moved rejected. That was none moved rejected. This point, Rashid Rahman has applied,
Huge also.
but none moved rejected. It is page number 9, man.
তো non-move rejected দেখা আমাকে petitionটা দেন। কোথায় ওটা?
I have annexed that judgment.
Yeah, extension. Yes.
at page number 9, my lord, of their petition. None appeared, my lord, and it was rejected on merit. And 100 kg commercial, very much above the commercial quantity, my lord. Gaja was recovered, my lord. Seizure list, my lord, page number 22. My lord, CFSL, I have just pointed out. CFSL report.
Page 22.
Seizure list.
Twenty-two. 22 is a Caesar list.
Seizure list.
Yes.
My lord, and from the position, very much position, my lord, from their position, it was, my lord, recovered, contraband, my lord. My lord, Rashid Rahman and Niranjan Bormon was there in the truck, my lord. From truck, it was recovered. CFSL report, my lord, 131, 132.
Yes.
Very much above than commercial quantity, my lord, exclusively from their position, my lord. And my lord, only 173 days they are in custody.
And as regards to the ground of arrest,
My lord,
Page 29. Page 29 and 30.
29 and 30.
Narayan
My
Lakshman.
lord.
Narayan Lakshman, the first one is
Narayan. Niranjan. Niranjan. Niranjan.
oh, not Lakshman, that is Bormon. Niranjan Bormon.
Niranjan. Bengali writing.
29 and 30.
Rashid Rahman.
The name of arrest.
Nin. You are private.
My lord, judgment has been given, let it be kept in the record.
Seven nine eight.
আচ্ছা ওটা তো তাহলে আরেকটা কপি করে আরেকটা তো দিয়ে প্রত্যেকটা পাতা ফটোকপি করবেন। নেক্সট
Item number 8.
About the petition, Lordship, supplementary to the. Lordship, this is the supplementary affidavit.
FIR
No, Lordship, remember the charge sheet was of another case.
charge sheet was of another, not the FIR.
Court granted leave on to me on the other day,
charge sheet
charge sheet.
তাহলে প্রথমে লিখে নিন
আমার আগের ব্রিফটা দাও। Lordship, before we enter into the niceties, Lordship with immense experience knows better than me that in once in a blue moon, we get such a case where nice law points are there. And it feels pleasure for an advocate also to place those facts before my lord. And obviously, the same should be from the other side also. Lordship, this is an example of that type of case. The case is, Lordship, of NDPS under section, kindly comes to page 13, that is the letter of complaint. Under 21C of the NDPS Act, simple 21C. So apparently they say as per the prosecution is a commercial quantity. Now I will try to demonstrate, backed by our High Court judgment as well as Supreme Court judgment, whether this amount which has been received falls under the commercial quantity or not. This is my simple submission. Prior to that, Lordship, kindly comes to page 11 of my petition, where on March 25, it was dismissed being not pressed. So not on merit. I'm renewing my application. Before Lordship kindly comes to the seizure list, which is in page 15. Got it, Lordship? Okay. So admittedly, what as per the seizure list, 265 grams of brown sugar has been recovered from possession of Akhtar Ali, that is the petitioner. Lordship, 265.
267.
267. As per the schedule of NDPS Act, 250 gram is the commercial quantity. So it's above commercial quantity, 17 grams. Now, the investigation is completed and CS, charge sheet has been submitted, page 21. Page 21, charge sheet has been submitted. What is lordship? Okay. Now, from the charge sheet, we find that the contraband were sent to the FSL, CFSL, which is I have annexed the same on page 24, lordship. At page 24. Got it, lordship? Okay. Now, result of examination. Can you see the portion result of examination? Using suitable chemical test and instrumental method of chemical analysis, what has been found? Dicectromorphine, that is heroin, 6-monocitryl and morphine. 3 salts were identified from this sample. What is lordship? 3 type of salts. Now, from the FSL report, lordship will not find what type of tests were conducted. This is my first point, because as per the NDPS provisions, there are 2 types of tests which is mandatory for the prosecution to conduct. One is qualitative analysis, second is quantitative analysis. I'll show you, I will demonstrate from the act. Why, lordship? Why I am saying so? Qualitative analysis says this salt identifies this salt, but to fall under the purview of NDPS Act, there should be, as because there are 3 types of salt, and each salt has a separate yardstick for coming to commercial quantity or not. So there should be quantitative analysis also. May I take your lordship NDPS Boita? Kindly see, lordship, rule 14 of the Narcotics, Drugs and Psychotropic Substance Sampling and Disposal Rules 2022.
Yes.
Rule 14. What is lordship? May I read? Expeditious test. The chemical laboratory shall submit its report to the court of magistrate with a copy to the investigating officer within 14 days from the date of receipt of the sample. This is now proviso. Provided that where the quantitative analysis requires longer time, the results of the qualitative test shall be dispatched to the court of magistrate with a copy to the investigating officer within the said time limit on the original copy of the test memo. And in the next 15 days, the result of the quantitative test shall, the mandatory provision, shall also be indicated on the duplicate test memo and sent to the court of magistrate with a copy of the investigating officer. So this shows that 2 types of test is mandatory. One is qualitative, another is quantitative. This much I have demonstrated. Now, for my satisfaction, lordship, kindly see rule 11, the top. What is the quantity to be drawn for sampling?
Yes.
Now, rule 11. For my satisfaction, lordship, I am giving much trouble. At the top, rule 11. Got it, lordship? Quantity to be drawn for sampling. As because, lordship, I pause for a moment. The NDPS Act being a stricter act, the provisions should be complied strictly.
except in cases of opium, gaja and choros. Here we have brown sugar, neither opium, neither gaja nor choros, where a quantity of not less than 24 grams shall be drawn for each sample. In all cases, not less than 5 grams shall be drawn from each sample. So minimum is 5 grams, maximum is 24 grams. Got it, Worship? Now, kindly comes to page 24 once again, the sample, the FSL report. A1, 3.37 grams. So, the quantity sent for analysis is not as per the provision laid down in NDPS. Minimum is 5 grams, maximum is 24 grams. So it should be at least 5 grams. So it's below that. But this is one, but my submission is regarding that quantitative and qualitative. देखिए NDPS wait. Lordship, I am tempted to take your Lordship to NDPS rules section 2 for an example.
NDPS?
Rules, MDA Act section 2. Why I am saying so, Lordship? Kindly appreciate one fact. Why the 2 tests are mandatory? Why the 2 tests? For an example, Lordship, if I take a cough syrup in my hand and wash my hand in a bucket of 5 liters water, what happens? The quantity of cough syrup in my hand spread over the entire 5 liters. So if the qualitative test is done, the presence of codeine will be there. But to come to a purview of NDPS, there is a provision that the concentration should be 0.2% and above. Kindly comes to page section 2. Section 2. Ten 5.1 opium derivative. What is, Lordship?
10.5.1.
There is 15. XVI Roman.
15.
Opium derivative. What is, Lordship?
Opium.
Okay. Now come to C. Opium derivative. What are opium derivatives?
Opium means.
Opium
16.
16. In my book, absolutely. Comes to C. What are opium derivatives? Phenanthrene alkaloids, namely morphine, codeine, thebaine, and their salts. So, morphine is nothing but an opium derivative. It's a salt of opium derived from opium. What is, Lordship? Next, dicyclomorphine, that is the alkaloid also known as dimorphine or heroin and its salts. So these are all opium derivatives. Next, all preparations, E is very important, Lordship. All preparations containing more than 0.2% of morphine or containing any dicyclomorphine. So it has to be containing more than 0.2% the salt density. That is the reason, Lordship, the quantitative analysis has to be done. Whether what has been found in the examination, that is dicyclomorphine, morphine in our case. So these are nothing but opium derivative. So the percentage has to be more than 0.2%. Reduction.
Yes.
So the percentage of salt has to be, the concentration has to be more than 0.2%. What is, Lordship? Now, if in a case, in such like this, Lordship, where the examination report does not say whether any quantitative analysis has been performed and what is the quantity, then at the stage of bail,
Yes,
at the stage of bail, whether this point can be raised, and if raised, what is the opinion of the Honorable Apex Court in this? Before that, Honorable Apex Court has gone one step further and stated that in absence of any quantitative analysis being done, the prosecution is debarred from taking the plea that the salt comes under the contraband falls under the commercial quantity even. I place a judgment, Lordship, SCC, state 2021, kindly comes to para 12 and 13. May I read along, Lordship, if permitted?
yes.
Para 12. After careful examining the arguments advanced by the learned counsel for the parties and having cursory glance at the records, we are of the opinion that impugned order cancelling the bail, in this case, Lordship, the bail was cancelled. Bail was granted, subsequently cancelled. Cancelling the bail granted in favor of Bharat Chaudhary, accused number 4, is not sustainable in view of the fact that records sought to be relied upon by the prosecution shows that one test report dated such and two test reports as such and one test report as such in respect of the samples tablets drawn and sent for testing by the prosecuting agency conclude with a note appended by the assistant commercial examiner at the foot of the report stating that quantitative analysis of the samples could not be carried out for want of facilities. In our case, Lordship, no such averment even. In here, we find that they have admitted, yes, we could not do. But in our case, no such averment even. Now, para 13 is important. In the absence of any,
Yes.
para 13, in the absence of any clarity so far on the quantitative analysis, such in our case also, Lordship, of the samples, the prosecution cannot be heard to state at this preliminary stage that the petitioners have been found to be in possession of commercial quantity of psychotropic substance as contemplated under NDPS Act. Stop. The next part is regarding that case, Bharat Chaudhary's case. So, in our report also, there is no clarity so far as the quantitative analysis being done. In our case, Lordship, so in our case also, there is no clarity as to the what is the quantitative analysis or why the quantitative analysis could not be done. No averment in our case. So, as per the Supreme Court guideline, prosecution cannot be heard to state that at this preliminary stage, so it was a bail stage, that the petitioners have been found to be in possession of commercial quantity. In our case also, similar, Lordship. Now, may I hand over coordinate bench judgment, bill in NDPS case, 2026, April, wherein in absence of quantitative analysis, bail was granted. Devo? So, আমার কপি কোথায়? সাদ্দাম? ও, তোমার কপি দেওয়া আছে। এটা পড়ে নিয়ে নিবি? পড়ে নিলাম। Lordship, may I read, Lordship? Here also, Lordship, 407 grams of brown sugar was recovered from the petitioner. Lordship. Kali see is the last portion. It is also have been contended that there has been no quantification of the contraband which has been seized. Next para, learned advocate appearing for the state on the other hand opposes the prayer for bail and submits that one absconding accused person has been arrested and another accused person is still absconding. So no reply from the state regarding quantification of sample. I have taken into account the chemical examination's report which reflects that seizure quantity contains same as our case, Lordship. The 3 salt found in this case same as our case. Dicyclomorphine, monocyclomorphine, and acetylcodeine, that is codeine. Having considered that there has been no quantification in the chemical examination report, so in our case also, I am of the view that the judgment of Honorable Supreme Court in Sentu Sheikh versus State of West Bengal, arising out of SLP criminal number such and such, I'm handing over that also. Lordship, Sentu Sheikh, I'm handing over that. Is applicable to the present case. As such, the prayer for bail of the petitioner is allowed. Now, Lordship, this is Sentu Sheikh, which was relied upon. Sir, Sentu Sheikh. Lordship, second page, 1, 2, 3, 4th paragraph. The question arises. What was it? As to whether Section 37 of NDPS Act would have application to the case on hand, given the fact that the prosecution has not separated the 3 ingredients, such in our case also 3 ingredients, allegedly found with the appellant, so as to quantify them. Quantify them means quantitative analysis. We therefore find no ground to continue with the incarceration of the appellant Sentu Sheikh at this stage. The appellant is allowed, setting aside impure judgment, granted bail. Now, Lordship, another judgment I am banking. Akhtar Ali. Another judgment I am banking upon of the coordinate bench. Sadat, Lordship, kindly. Sir. Here also, Lordship, March 30, 2026. Similar point. Heroin. Similar salt. 306 grams were there. Mine is much lesser, Lordship. Relying on Sentu Sheikh, bail has been granted by the coordinate bench. My custody is about 300 days, Lordship. Charge is submitted. Lordship will find in Sentu Sheikh as well as the coordinate bench judgments, all the 3 ingredients, 3 salts, quantification not done, quantity analysis not done, bail granted. NDPS and recent judgment. Same salt.
Yes, anything more?
Lordship, I reserve my right. If Lordship requires, I'll give answer to.
Your Lordship will come up with an answer. Will come up with an answer.
When?
From 15th.
Have you received on
15th.
Monday, 15th? Have you received the copy? Of
Yes, sir, Lordship, I have given.
Judgments.
I have given. To sir, I have given. Your senior is having it.
Single state also accepts from an order of Calcutta High Court. Dr. Bajju.
দুটা ম্যাডাম
এটা কবে বললো?
Item number 10.
ভাই চালাচ্ছি আমি করে দিচ্ছি, আমি করে দিচ্ছি সব নামটা। আমি বলে দিচ্ছি, বলে দিচ্ছি।
Item number 11.
11 হ্যাঁ লর্ডশিপ, আমি বলে দিই আগে। Lordship, in this matter, Lordship, on the last occasion, my learned friend has already apprised this court with respect to arrest after sunset. That was the issue. So in the earlier case that was rejected today, that is a different, that detention was, the accused was detained previously before 6 and after that. But in this case, what I have found that entire process was after sunset and in between sunset and sunrise. So I need only, just for my satisfaction, Lordship, 1 day more time, Lordship. I'm pressing it
Monday.
fairly.
Monday.
Monday অসুবিধা হবে না? Monday, Lordship.
মানডে কতগুলো আছে দেখুন তো।
It is a STF matter.
No, no,
Huge amount of years there.
পেনটা কই আমার
Item number 12.
12 beta na hoga. My lord, in item number 12, for the
Well, watch it.
petitioner, my lord.
Citizen.
My lord, on the last occasion, that is yesterday, and my lord has taken a view regarding the videography and all. So that is one of the point. Before I come to the point of videography, section 105 of the BNSS, my lord, there are certain other points also. First of all, my lord, three ladies, they all petitioners, so one of them is a petitioner, 3 accused persons, all ladies. They are apprehended.
Yesterday, I have not expressed any personal view.
No, that is
I
as
had-
per the law, my
As
lord.
per-
Yes, as per
As
this.
per the
That's true.
judgment and orders passed
My lord,
earlier.
my lord has rightly said. Here the case is, my lord, apart from the videography and all, there are other certain points. There's a violation of 52A2 of the NDPS Act. I'll be coming to that point later on, my lord, but prior to that, what is the case, my lord? 3 ladies, they were apprehended with some contraband articles in a railway station.
Hmm.
And the apprehension was they were detained in the morning near about 4:50 hours, that is morning 4:50 AM.
Hmm.
And the search and seizure took place on 11:55 hours.
Hmm.
So here they were detained for a long time. That is one of the ground. Now here, there are 2 independent witnesses
Hmm.
who are male.
Hmm. Yes.
They are in the seizure list, their names are there,
Hmm.
but they have not witnessed the search and seizure.
Hmm.
Because as per the complaint, my lord goes to the complaint of this case. I'll take my lord to the FIR first.
Hmm.
So 15 packets of Yaba tablets were recovered from them. The weight is admitted, that is 3392 grams, 3 kgs, 392 grams. Much above the commercial quantity. Now, after they are apprehended at 14:50 hours, my lord, they were in the station. The complainant, he could not arrange for the independent witnesses because all the persons in the railway station, either they were boarding the vehicle or they were boarding the train, or they were unboarded from the train, my lord. So she could not, she could not, and later on she could not get any independent lady witnesses also. Now here, the entire search and seizure was done inside a bathroom of GRP. Inside the bathroom of a GRP, where 2 lady constable and the complainant herself was present. But neither the gazetted officer was present at the time of search and seizure, nor any independent witness, lady witnesses are present. I'll take my lord to the seizure list. Station. Now the seizure list, though it's a type copy, which was prepared at the spot, it's very doubtful. Though in the complaint they have stated they were carrying a portable printer with them. That is also quite doubtful, my lord. Now here, it's written the name and address of the witnesses. That is one Pintu Bourbon and one SI Abhishek Lama. So the only independent witness is Pintu Bourbon And this SI Abhishek Lama, he is a police personnel who is a member of the raiding party. Though in the complaint, it is stated that this search inside the bathroom was carried on in presence of the complainant as well as two lady constable. Though they have cited an independent witness, a police personnel, but they have not cited this lady constables as a witness to the search and seizure. Neither the signature is there. Very doubtful case. In the morning, arrested about in the morning at 4:50 hours. Thereafter, search and seizure took place near about at 12 after 7 hours. So where they were kept during the 7 hours, nothing is there. And more or less the gazetted officer, he is also from the STF. He was a member of the raiding team, though it is not, they have not admitted that. Obviously, they will not admit it because their case will be frustrated in that case. But he was, because the raid has been conducted by the STF, the gazetted officer also belongs from the STF. Another thing, because by one, if there is sufficient discrepancies, my lord can come to a conclusion that this is prima facie, there is no case against this petitioner. Second, in the FIR, when they were asked before the search that whether they want to search the person who will be searching them, they declined. It's written. I'll take, my lord. My lord, this is page number 15. Thereafter, Inspector Sri Shevang Norbu, I'll just read the relevant portion. Shevang Lama intimated the above noted 3 detainees and also served notice under section 103 BNS writing that if they wish, they may be searched.
You are referring to page number?
Page number 15. This is the FIR of the main application. Last paragraph, page number 15. Thereafter, Inspector Sri Shevang Norbu Lama, he is the gazetted officer, member of the STF, intimated the above noted 3 detainees and also served notice under section 103 BNSS in writing that if they wish, they may search every member of the searching team and the vehicle with us before the search of their person. What they have answered? Then all of the above noted 3 detainees declined the search. And now, in spite of they have declined, how these things are manufactured, my lord will find in page number 20 of my application. In complaint, it is written that I have declined. I don't require to search the person who will be searching us. But in page number 20, they have prepared a nil search, nil seizure list. They said the accused declined. They don't want to search us, whereas there is a nil seizure list. These are nothing. These are all things which are prepared in the police station. One by one, everything is done. These persons are arrested. These yerba tablets, these are, my lord, sometimes these are search and seize without the person who carries them. And this type of persons are implicated in this case. Another point regarding 52A, that is very important, my lord. And if there is a violation of 52A, at this bail stage, and if it is brought before the court, my lord, I am entitled for bail. 52A, subsection 2, where any narcotic drug, psychotropic substance, controlled substance or conveyance has been seized and forwarded to the officer in charge nearest police station or to the officer empowered under section 53, the officer referred to in subsection 1 shall prepare an inventory of such narcotic drugs, psychotropic substance, controlled substance, and containing such details relating to their description, quality, quantity, mode of packing, mark, number, or such other identifying particulars. I just keep a question to the other side, the prosecution, whether any such things are there, whether the color, the mark, of those tablets which have been so-called, my lord, which has been recovered from these accused persons, whether those have been done or not. There is a clear violation of section 52A(2) of the NDPS Act. Now I'll come to the FIR again, my lord, regarding the kit they used. So much contradictions. How can my lord come to a conclusion that they have a case? Now, the kit they have used after the search and seizure, though was search was seizure in a bathroom, nobody, versus videography could not be done. They have taken a ground that due to modesty, it could not be done. That cannot be a ground. Because in search and seizure, videography to clear being every should be very clear. Because in NDPS cases, there is every possibility that innocent people are taken into custody, and all this for these reasons they are in custody for a long time, and even they are convicted also. So here, after the test was done, hello kit. My lord, this is page number 16 from 1, 2, 1, 3, 4, 5, 6. I then made, my lord, got it? I then made small cuts each packets and withdraw one sample of the tablets in the packet and tested them with the drug testing kit. All of them came positive for presence of traces of amphetamine. This is as per the, though it falls within the NDPS, my lord, the list of the NDPS. But here, my lord, at the time after the FSL report came, something else was there. Now the FSL report আছে. My lord, as per the FSL report, it's in the CD, my lord. We have I have the copy of the charge sheet also, my lord. As per the charge sheet, it came methamphetamine. That is entry number 159. And as per the spot kit detected, it came entry number 152, amphetamine. So these are the another contradictions, my lord. The gazetted officer as well as the witnesses in the seizure list, they were outside the washroom. They have not witnessed the seizure. Who will depose this before the court? The complainant will always try his best to prove his case, to improve his case, as well as to prove his case. Only on the basis of the statement of the complainant, the court cannot come to a conclusion that they are really liable for this offense. Here, the independent witness, the statute is very clear. Why the provision of independent witness? Why the gazetted officer is required? They have not witnessed the search and seizure. An NDPS case is totally based on search and seizure. If the search and seizure is, it's not as per the law, then even section 37, bar of section 37 will not apply here. They could have easily bring to, because they knew that there are 3 ladies persons are there. No female witnesses were there, independent witnesses.
What has come
And
out?
last minute, sorry.
What has come out after the test?
It came out methamphetamine,
Which,
entry
which
number
page?
159.
Which-
No, this is in the FSL report.
You have not.
Yes, methamphetamine.
This is in the
It will be in the-
seizure list, page number 38.
Huh?
Yes,
Page? Is it provided? No.
yes, we have given the charge sheet. It's written in the charge sheet, my lord. Page? Underline good, additional Kannada, yeah. No, this is in page number 37. 37 page number. Just before the last paragraph. I has received the expert report. Samples and contraventions to the contents of the samples were found. It's written. Methamphetamine. This is entry number. This is entry number 159. And amphetamine is entry number 152 of the list. And my lord, regarding the, there are other charge sheet has been filed. No prior criminal antecedents are there. No risk of absconding the permanent resident of Kuch Bihar. And regarding the grounds of arrest also not read and explained as per the Rajesh Shah case, my lord, in their language, my lord. If my lord goes to the grounds of the arrest memo issued as well as the grounds of arrest, it is clearly they have signed in Bengali, whereas it is written in English. So nowhere it is written that the grounds of arrest were explained to them. So these are the points. And considering all this, that search and seizure, no videography was done. The main thing was not videograph. I have videographed the other things, but the main search and seizure from the person, that was not videographed. And that explanation was also not there. The guided officer has not seen the search and seizure. And the independent witness, though they have signed the search and seizure, if they are asked at the time of giving deposition whether you have seen the search and seizure, what will be their answer? They will say no. So the trial will automatically cannot stand, my lord, on his leg. So if the trial cannot stand, I am entitled to bail. So humbly pray that this petitioner may be granted.
Last thing, my lord. My learned senior lords have raised a question regarding grounds of arrest and whether it was explained to the used in vernacular language or not. If I can have my lord for a moment on his own petition, page number 24.
Yes.
In the bottom, there is a note written, read over, translated to Bengali and explained by me to the detained person in presence of lady CBF.
That is notice under section 50.
Then,
No, that is a notice, not the grounds of arrest.
then I'll come to the grounds of arrest. In the arrest memo, just after the arrest memo, my lord, that has been taken care of.
So there is no. नाम की बुलबुल लग रहा है.
Before that, if I can have my lordship for a moment on this, because this is also taken as a ground. Regarding, this was taken as a ground.
No, just regarding, regarding the memo of arrest, there is no provision for written.
Page 62. 52 a violation was alleged, now that is not there. The description of all the articles is there in the inventory.
Sure.
There is no section 50 violation that has been alleged. Now, my lordship, coming to the videography, because that has been stressed upon. If I can have my lords for a moment on page 16 of the application.
He has alleged that section 52A subsection 2
Yes.
not complied.
Section 2 is, the answer is there, my lords, in page 62.
Oh.
That has been taken care of. Now, if I can have my lordship for a moment on page 16 of their chat. What was the difficulty? I will explain those and that will answer some of the other questions that we have.
Page
Page 16 of the
1 such.
application that we have.
Yes.
And there in one third paragraph.
Hmm.
I then being assisted by LC such and such, took at first the detainee, Apika Bibi, to the rescue. We draw 5 brown color packets from her body, which was concealed under her wearing apparels. Now, problem is that if a female is carrying something inside her wearing apparels or even undergarments, the rate also coming later on. Then videography becomes because in that case, the dignity and the privacy of the accused gets compromised. That is the reason why go and the videography was done, but for that particular incident, wherein the recovery, actual recovery was to be done, that couldn't be done. And I appreciate the officers for not doing that. Letter it says, I then brought the 5 recovered packets and then detainee Apika Bibi outside and marked them as such and such and such. So the best that could happen was done. I then took another detainee, Achinima Khatun, to the restroom when she withdrew 5 brown packets from her body, which was concealed under her wearing apparels. I then brought the 5 recovered packets and the detainee Tachima Khatun outside and marked the 5 recovered packets with P, H, I, and J. Then at last, I took the detainee Farida Khatun, this is the present petitioner here, to the restroom, where she withdrew 5 brown colored packets from her body, which was concealed under her wearing apparels. Now coming to the question of amphetamine and methamphetamine. Actually, what happens is this amphetamine, this is a raw substance, and methamphetamine, both are under this. Methamphetamine is nothing but a slightly improved version because the meth is added with the amphetamine. Now, when I initial test happened, now these handy test kits that are carried here, they will show the same property for amphetamine and for methamphetamine. That's what we in this case, 3,392 grams, huge commercial quantity was being carried by these 3 female persons here. Way above the commercial quantity which they were hiding inside their wearing apparels, and they were traveling, and when they devoted there at the railway station, they were apprehended, and that is how the search and seizure in this case was. So videography, yes, of course, has to be done, but there are certain situations, real life situation wherein some care of decency and privacy has also needs to be taken care of. The charge sheet has been filed. There are total 13 witnesses, and there is not one, there are 2 independent witnesses. So the independent witness team also has been taken care of. Despite all this, happened 4:30 in the morning.
Who are the independent witnesses?
Yes, there are 2 independent witnesses. There in the charge sheet.
People were yesterday in this season.
Yes.
You are always Inspector Abhishek class. Reading team. Member of the
No, at item number 10, this Sagar is also of independent. All the necessary compliances has been done in this case.
Chart sheet. Page number.
Where you have the chart sheet?
services will be taken care. There is page number.
You have attached the chart sheet to the application, which is at page number 12.
Number 20, this is my application. CD and CD, obviously the CD. This pink bottom, color number 5. Pink bottom. And first two is the Abhishek. And Abhishek Pama is the office. Member of the reading part. The railway station, whether it is believable that they won't get independent witnesses. Easy railway station like Hindi,
No, this, we have, that is also very old, I think the water is like, it is clear. All the rails from the north eastern, they must to the railway station. Is it really understood? See the rating. A long time. The date of incident is 16th of October 2025. Yes. Not the point. That is right. Why it is 16 means about 8 months. That is what that is what is not that is something. Oh, the bit of the section 105 of the Venus is very clear. Well, regarding that color of hollow shape is there. And was very much
Complete.
apart from that recently, that is on April to 27 color. Oh, this is not a Delhi High Court, not a Supreme Court, but I just said my restriction are they are also regarding the video club, they was there. This is also an case, same thing. Person it was same thing, like my case.
shall come next week. Yes,